So this week, I wanted to talk about this World Series case. So imagine that. All right. So you are an Atlanta Braves fan. So it's easy for you to imagine.
Well, I mean, yes, I am, but it might be on hold this year. No, I'm still a fan. It's just frustrating this year. Let's just leave it.
Very
frustrating this year.
All right, but imagine if you got tickets. Okay, maybe not this year, but imagine they went to the World Series, which they did in 2021.
Yep.
And you're in the stands. They win. You're celebrating. Things are going crazy, and then boom, like your wife Kate gets hit in the eye with a baseball. Yikes.
I mean, that's a problem.
We're going to have a problem.
Yeah, we got lots of problems. The first thing you do when you have a problem is just ease the pain. So how we ease the pain, and this is going to come into play later on this case as well, so don't worry about it.
Okay. We'll get to the facts in a second.
Yeah, so there you go. Well,
anything to mitigate the damages.
There you go.
Yes, cheers.
It's been a little bit. Glad to have y'all back, and glad to be back.
Oh, I mean, I you know what? I did actually miss that taste just a little bit.
Oh, I didn't.
Because you know what? It tastes like good times at the podcast table.
Exactly. They're a little warm today. They're a little warm. You know, keep you. Circle K didn't do me right.
They're not hot, but they're not cold.
Exactly.
They're cool though. They're good.
Yeah, they're fine.
So I no longer associate it with like tailgates and fields from my youth. I now go, this tastes like the podcast.
I guarantee you Reid didn't miss the flavor.
No, I didn't miss it. I mean, I've tried to, keep Bud Light in business.
Does it taste a little sweeter when you drink it with us, though?
Oh, yeah, for sure, definitely. It just eases it a little bit, all that. But.
All right, well, in today's episode, by the end of this episode, we're going to make sure that the listeners and viewers understand why this isn't, with the baseball case, this isn't a typical, like, the fan assumes the risk.
Yeah.
So to talk about the facts a little bit, Reid, I know this is one that you brought to the table for us to talk about, being an avid baseball fan.
Sure.
Not so much a Braves fan these days, but an avid baseball fan.
I am. I'm a huge Braves fan.
He's a huge Braves fan, just deeply disappointed with the outcomes this year.
That's right.
Yeah.
So, I mean, so to me, it's one of those cases that, Shawn, just in law school, this is like the base of premise liability. I mean, I love premise liability. I do a bunch of premise liability cases. And so, the baseball rule, so to speak, is one of those that is just, it's the foundation of premise liability. It's the foundation of how you learn about assumption of the risk. And there's a lot of a foundation about waiving your rights and on the ticket. You actually have a waiver that you're going into this event. So it's pretty groundbreaking for this not to be ruled on and just kicked out just on that first part of, hey, this is automatically kicked out of court. Yeah. So that's what I kind of found interesting. But the real question, and this is another. Go ahead.
Hold on, before you get too far in that, let's break down the facts, right, of what happened in case people have not seen.
Sure.
Yeah, let's talk about what happened, and then we'll talk about what the actual, the bottom baseline law of premises liability is, and what these different exceptions are, and what they mean to this particular fact pattern.
Perfect. Right. So a young lady, Mayra, and her husband, Scott Norris, were at this baseball game, and she essentially got hit by a baseball that was not during actual play, as I understand it.
Right.
It was during the 2021 World Series that was they were celebrating. And
was she a Braves fan?
I don't recall reading whether or not that's true, but that would add an interesting
without it being callous. She's not anymore.
Oh man, hate to laugh, but that's I don't think I would be a fan that much anymore either. But I guess so. One of the players, Jorge Soler, actually threw a ball into the crowd and caused multiple injuries. She has disfigurement claims, and initially the lower court system dismissed it using what's called the Georgia baseball rule, right? Or the baseball rule. Is that its official legal name?
There's a case name, but that's what everybody calls it. I mean, it goes back to assumption of the risk, but I mean, everybody calls it the baseball rule, and you call it the baseball rule, and that goes for football and every other sport. I mean, if you are going into an event that, the normal course of action, things happen, you kind of have to expect that you may be in danger, that kind of thing.
Right, for sure. And so just this week, what's happened is that the Georgia Appeals Court has overturned that and said, nope, the baseball rule does not apply in this case. And from what I understand and have read, it's because this wasn't during the baseball game. That actual game was not happening. This was after the game. Celebrations were happening. At that point, this would be my layman's take on this. Mm-hmm. If you're in the stands and the game is over, then you're not thinking about how to protect yourself from flying baseballs at that point, because you're not thinking that that's going to happen. And then the MVP of the game or the whole series launches a rocket into the stands, and now you got a lot of injuries that she's dealing with.
Sure, and she had some significant injuries. Apologize for that. And what we have to think about is the bottom baseline of businesses, including stadiums, sports teams, and what they have to do in order to protect the people that they are inviting in. Right. These are called invitees in the law. You are inviting someone in for mutual benefit. Mm-hmm. You're going to make money off them for ticket sales, concession stands, merchandise, and they're going to get some type of a benefit, whether it be from shopping at your store or watching the baseball game, et cetera. Yeah. The standard of care, which is what people have to live up to, what businesses have to live up to, is that they have to use ordinary care in making sure that their premises and approaches to their premises are safe. Right. And that includes inspection, routinely inspecting the premises. It's not just I own this business and when I opened it, everything was safe. There has to be some sort of guideline in place or policies, procedures for making sure that things are, because you're inviting people in. Yep. It's a higher standard than your home.
Right. It's a higher standard than if I invite Shawn over to hang out and just he's not benefiting me financially. So that's going to be a higher standard when you are, like Shawn said, an invitee.
You're benefiting from their
presence, right? Okay. So you have to make sure that the premises is safe and
based on the fact that these types of places have more people, therefore more opportunities.
Well, it's not even more people. It's just the contractual relationship between you are inviting members of the public in for your benefit.
Yep.
Okay. Yeah.
And therefore, you have a little bit higher standard of care for making sure that your premises and approaches are safe for those people you are inviting in to benefit from. And then, obviously, we have exceptions to these rules. People would think that, people come to us all the time and say, okay, well, I stumbled in this parking lot of this grocery store and I want to file a case. And we talk to them and, well, why did you stumble? Was there some unsafe condition present that made you? No, I just stumbled and, I twisted my ankle and fell down. Well, why would the law allow us to hold a business owner responsible for your uncoordination or your misstep?
If you're just clumsy.
Or clumsiness or whatever. It's not just because you got hurt on a commercial property that you're therefore entitled to recover and they have to pay for your medical bills. It's that you have to prove that there was some type of unsafe condition that they knew about.
There's your key. I kill it all the time. But knowledge rules these cases.
Yeah, that they knew about.
Oh my gosh, I have a premise.
Or that they should have known about.
Yep.
Yeah. Can we, while we're talking about this, can we time out on the baseball story for me to give you a real life hypothetical?
Sure.
Okay?
Absolutely. It's not a hypothetical if it's real life. But I will give you some advice.
Okay. So recently we were at a local fast food chain. And I only probably noticed this because I work for a personal injury law firm. But as we're sitting there, a manager or someone from the back behind the counter yells out into the lobby and says, please be careful. There's ice there that has water on the floor.
Sure.
Please be careful. We'll get out there to clean it as soon as we can. Please be careful. So she is verbally warned. Most of the people who were standing there probably heard her. Some people maybe didn't. Mm. But they hadn't put any sort of, at that point when she said it, they had not put any like a wet floor sign or anything out. And I thought to myself, and I can't believe I forgot to get to work on Monday. I was going to be like, oh my God, what if I had slipped? Because she verbally told me, but what if I hadn't hurt her?
Well, and there's no
sign.
The answer to that is it's a maybe, all right? And so what you have to look at is the reasonableness, like Shawn was talking about, and how long had that been there, right? So if it had just happened or something had just been spilled and the person is not cleaning it up because they want to finish their order or finish making the hamburger, whatever, then that's probably not reasonable. But if they can't get to it and the only thing they can do is tell you and warn you verbally, and it hadn't been there very long, and their policies and procedures say that you're supposed to check it at X amount of time, then they're probably not going to be liable, right? So sometimes there's some grace period in there, right? It's not a specific amount of time.
No hard and fast rule,
right? About timing, right? So, but if it had been there, let's say an hour, and they're just every time somebody comes in, they're going, "Hey, watch out for that." Well, then you're probably going to be liable if somebody falls on it. But if you're sitting there and you're taking an order and you see something spill and you go, "Hey, y'all be careful, something just spilled over there," and somebody falls in it, you're probably not going to be liable because it hadn't been enough time for them to resolve the issue.
Gotcha.
So it really depends on some other variables there too.
There's a lot of factors that go into that. Let's say, there was 15 people in the restaurant when this announcement is made, and then you're one of the people that come in after that announcement is made and slip on it.
Yeah.
Or, you have just ordered and just sat down and you're waiting on your food, and they make this announcement, watch out over here.
Yeah.
And then they come and deliver your food to your table. You eat your food. You've been there 30 minutes, 45 minutes. And this kind of thing slips your mind,
nice pun.
Or you, or you just even didn't even think about it because you rationally thought that this thing would have been cleaned up by now.
Time, right?
And you walk by that same area and you do slip and fall and get injured. That's something that a jury needs to decide about that, whether or not you should have had notice of the condition and avoided it, or whether or not the notice that you were given has kind of expired.
Yeah. And one thing I think it's very important is, and going back to the baseball case and with this claim, and basically any premise claim, when people read this in the paper or online or whatever about, hey, that the Braves could be liable, blah, 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 they think it's an automatic, okay, that the Braves lost, this person can recover. Yeah. That is not what's happening. The only thing that has happened is you are allowed to present this to a jury or the decider of the facts.
Yep.
So that's what we talk about summary judgment motions all the time. The baseball rule essentially says if you get hurt, you're not even allowed to bring it into court. All this is saying is you are allowed to present this to the trier of fact. And so just because this lady won this part and it goes back to the Superior Court, the jury could still rule, well, you're out there partying and these things happen, right? It doesn't mean that the business is automatically liable. And it certainly could be, what if people are in the stands, right? And you don't know me and you're the lady and I block your view, or I'm drinking and partying and I'm the one who kind of bumped you and made you get hit. Well, then it's my fault. It's not the business's fault. So all this is saying is you have an opportunity to bring it into the court system. It doesn't mean that you win. That's a long ways from that. And that's a very big distinction that most people just don't know when you read a story like this. Just because you get past the first hurdle, there's a lot more hurdles. And on top of that, you have an apportionment issue, which is, let's say they say, Soler threw it up the ball up there and he shouldn't have done that. Well, yeah, but he's 20% at fault. You're still 80% at fault because you're at a ball field and you should be paying attention to your surroundings. A jury could easily decide that.
Right. So in this case, so what's the difference, as we know, because I think I also sent to you guys the Court of Appeals, like from the, I sent you that whole thing that you could look through. So baseball rule versus assumption of the risk during a non-game situation. Like, what's the law of this? Like, how
it kind of works out is, I gave you the baseline of what business property owners have to live by. That's, kind of the minimum standard. And then when you get into these, different type of venues, and whether it's a retail shopping center, a small outdoor, place that sells mulch, or whether it's a stadium, they're all going to have different issues that they have to address.
Okay.
Obviously, with baseball, we wouldn't want fans sitting right behind home plate while 90-plus mile an hour fastballs are being fouled off. So we have, netting.
Yeah, and I think this was before they made it all the way around, but now you essentially have netting all the way around, except for the outfield.
Yeah, I haven't been to a baseball
for every
game in a
baseball.
Does it go past the dugout now?
Yeah, it basically goes all the way down. And I'm not sure if that was before this or not, but it doesn't really matter. But just that's like what you're saying, though, Shawn, is that the business is saying, hey, we've noticed that, because it became a problem 5 to 8 years ago where you had, more distractions in the ballpark, right? You had the
mascots dancing on top of the...
So that's the company trying to get you to look at something else. They want to make it entertaining, but if you're doing that and there's a foul ball coming, well, then they can be held liable. So to prevent liability, that's why they had to put the nets up.
You're trying to do the wave.
Exactly.
You're not paying attention.
Exactly.
And then that's what, what we say, assumption of the risk can be a defense for property owners, because if you assume that risk, there can be no recovery. But that's what the facts of a case have to kind of parse out, whether or not, there was netting to protect from random balls being, coming out of the field.
Right.
Whether it was a place that was reasonable to have that netting, whether or not it was during a game, like we discussed. Obviously,
is it normal for a baseball team to do this? Is it normal?
Is it normal for you to be in right field and a home run to be hit into right field?
Yeah.
Absolutely.
Yeah.
If you're sitting there eating your nachos and you get cranked in the noggin, the baseball rule is going to apply.
Absolutely.
Is it normal, for a bat to be broken? These are wood bats that the Major League Baseball requires wooden bats. For a bat to be broken during swinging on a pitch that comes inside and the bat goes flying over the third base dugout. Yes, it is.
Happens
you
all
as
the
a
time.
fan have assumed that risk. You're supposed to be paying attention to what's going on in the game so that you can avoid or minimize, any damages to that. As the game gets over and everybody's celebrating,
safe,
and you think you're safe, would you expect a baseball to come at you at a velocity that's enough to do the kind of damages that it did to this woman?
Yeah.
No.
Yeah.
And that's kind of what the court is saying.
And the defenses are going to be, which, like I said, it still goes back to the summary judgment issue of, and we're talking about facts, right? We're not talking about law right now, because the law is saying.
Oh, we're jumping back to the facts.
This needs to be decided on the facts. The law, that's what the law is telling us.
Well, and we're at the motion to dismiss stage.
Exactly.
I mean, there's kind of really two big stages in a civil type case. It's, you file a complaint, you file the lawsuit, you're going to sue somebody. And the opposing party, the defendant, has the opportunity to file a motion to dismiss that says what they have alleged they cannot recover on.
Even if all true.
Even if everything that they said is true.
Yeah.
They can't recover on because it's not, let's just say it's not against the law.
Okay.
Yeah.
So they don't have any recovery from us because what they've said is not against the law. And a lot of cases get decided on that. And that's what this ruling was. The initial ruling was it's not against the law because you went to a baseball game and the baseball rule applies.
And same thing. So, Shawn, I came here from a hearing that was a summary judgment that we won, but that doesn't mean we win the case. That just means that we have an opportunity to present our case now. It's a weird thing, but it's so important to understand that distinction.
And that's what, for obviously the layman, the motion to dismiss has to be filed immediately. It has to be filed at the beginning. You can't file one later on down the line. The motion, once you get past, if you are successful as a plaintiff in defeating a motion to dismiss, that's when you're allowed to do discovery. to, request documents, request, interrogatories or questions of the other side, to depose the people involved in it and gather evidence for your case. After that, that's when you have the motion for summary judgment. Mm-hmm. When both parties have as much information as they really can about each side of the case, and one party says that based on all of this evidence, the other party cannot prevail, which you can't file a motion for summary judgment as a plaintiff, but you can as a defendant. The defendant says, we've done all of this discovery, and based on this evidence, testimony that we procured, evidence that we procured, they cannot prove in court that this happened. Even if we give every inference to the plaintiff, they cannot prove X, Y, or Z in court based on this evidence.
Because there's always going to be a dispute in facts. Let's say me and Shawn are, defendant and plaintiff kind of thing. And, stupid thing. I say Shawn is wearing a blue shirt, and he says he's wearing a red shirt.
He should be.
And
it's on blue.
And if I'm filing the motion, regardless of what I believe the facts are being.
I got to support my Georgia Bulldogs. It's an off weekend this weekend for them. But I put my son this morning in a Georgia Bulldogs t-shirt, and my wife said, well, the Dogs aren't playing this weekend. And I said, it doesn't matter. It's a college football weekend. He can support his team.
There you go.
Well, I also didn't wear blue, so I really can't be throwing stones.
I'm just glad you didn't wear crimson.
Yeah. Well,
hey, it's not my fault that I married into Alabama, okay? Like that just happened, all right? I couldn't say, you know what? He's not.
Nobody's perfect.
You know.
Thanks a lot, Bo.
So, it's one. So if you're the defense in this situation, like the Braves are, you have to say, all right, if she says, the plaintiff says, I was sitting there minding my own business, I hadn't been drinking, I was paying attention, and I was hit. And the Braves have video showing that she was not paying attention, or her back was turned, or she was celebrating, or whatever
situation.
Yeah, in the summary judgment motion, you have to say, okay, whatever you say, meaning Shawn says he's wearing a red shirt. I don't believe he's wearing a red shirt, but even if he's wearing a red shirt, I think he's wearing. Now I have to say he's wearing a red shirt. Even that still does not show liability on my side. That's what you have to present it as. And so there's a big gap between that and then the next step of winning the lawsuit. This case, I take it to, Georgia Tech had a big win. They rushed the field, right? What are your actions when you're celebrating? That's assumption of the risk. What are the actions of the Braves? Do they allow their players to throw the ball into the stands? Are there previous players who have thrown the ball into the stands, which is a yes? You can use that as the plaintiff side. There's so many levels to this, and this is just that first little thing to go, okay, we're not going to kick you out of court so quick. We're at least going to hear the facts. I personally still don't believe that this is going to be successful for the plaintiff because in a celebration type situation, people are running around throwing the ball. They're asking for the players to throw the ball. I haven't seen the video. If it's on a line, maybe.
I've never seen the video either.
But if it's just thrown up into the stands, that's going to be hard to.
If I was a betting man, which I am not,
it's going to be settled.
It's going to be settled.
It's not going to be tried
because we have those thresholds.
So what this means for the average person is
that the Atlanta Braves or Jorge Soler. Or in combination are going to come together and go to this other person who was injured and say, we would like to settle this case. We'll pay you X amount of dollars so that it doesn't go any further. And that's the kind of different hurdles that you have. You start out with, I've been injured. I think it's somebody else's fault.
And then I'm a devil advocate here, and I'm the Braves. When you send that to me, I'm saying absolutely zero, nothing. Yeah, we're filing summary judgment. It's the baseball rule. It's over.
You open up the door for so many things in the future, right? Exactly. Because then somebody can come back and say, well, in this case, this 2021 case, you guys, you paid her. You settled with her.
You file this motion to dismiss.
Yeah.
And the trial court says, you know what, you're right. This is the baseball rule. You assume the risk by going to a baseball game.
Yeah.
And then, the Court of Appeals comes back and says, well, this conduct really wasn't encompassed in the baseball.
Yeah, it's not in the scope of the baseball action.
If you went to a baseball game under this baseball rule and a hot dog vendor had a a bucket of boiling hot chili on his belt because he could serve you chili dogs right there.
Right.
And he tripped and spilled all this on your lap and burnt you. Do you think that was covered by the baseball rule? No, that's not what it was intended to cover. It was intended to cover things that are generally accepted practices, generally accepted risk of attending a baseball game.
It's like the LeGarrette Blount situation in football years and years ago. The football player got hit in the head with LeGarrette Blount grabbing his helmet and hitting him with the helmet. Well, that's not a normal football action.
Wait,
right?
What
so
happened?
It's years ago, but he took his helmet off and he knocked this other dude in the head with his own helmet.
Player.
Yeah. But I'm saying as a player,
I thought you meant
normally if you're injured as a player, right? If you're injured as a player, there's no recovery. Yeah, but if somebody does that, that's an assault. And that's another thing that is so tricky in this kind of situation is we're talking about the Braves, and then we're talking about Jorge Soler. It's like, who actually is responsible here?
Yeah, you don't even play there no more.
Right. So, I mean, a person can take an action that goes outside the scope of what the business is doing, and then the business is not responsible anymore. Your chili example, if the Braves hired this guy to serve chili and they said, you need to keep it at the concession stand, and he said, well, if I put it on my hip, I can serve more people, I can make more money. Well, then it's on him. Yeah. And now then it goes. The next level is should the Braves have known that?
Exactly.
Should they have known?
And in discovery, which is the period after you successfully defeat a motion to dismiss, you would have depositions.
Yep.
You would interview witnesses. You would have a deposition of the guy that spilt the chili.
And that's your 30B6. So, that's when all that comes in.
Wait, what's 30B6?
Well, we're going to get to it. Well,
you would talk to this guy that is serving these chili dogs, and he would, say, I'm the best damn chili dog server at the the Atlanta Braves Stadium. I've been doing this for 5 years. Yeah, my clients like their chili dogs hot with hot chili. I've had this thing on my side. Well, even if Atlanta Braves said that we do not want them to do this.
And we didn't know. We didn't know.
Yep. It's like, well, he's been doing it for 5 years, and he's claiming he did it. So you should have known.
Should have known.
Because there should be some type of supervisor or someone that should have said something to him and stop this because it led to an injury because it was hazardous.
And a 30B6, to answer that, is the same. That what you do when exactly what Shawn's talking about is a 30B6 is somebody that is that the company has to produce that knows the policies and procedures of what's going on. And you have a list of topics that person has to be able to have knowledge about.
Okay.
So in this situation, you would have.
What is our policy about throwing balls into the stands during celebrations?
It is what is the policy of after the game, what are the players supposed to do? Where are they supposed to go? What is the policy for players giving souvenirs to the fans? What's the policy of where are
surely they have a policy about how you get said souvenirs to a fan.
So you have that. You go through all the policies, right? Yeah. And then you have to say or look at, are these policies being followed? And that's not just about this incident. It is about all the time. So if you have a situation where we say, like the chili guy, we don't allow it. We don't allow you to have chili and walk through the aisles. We only serve chili at the concession stand. Well, if you allow that to take place, even though your policies and procedures say you don't, if you allow it to take place, well, then it's back on the table again. Now you can recover again.
So you're saying to me, I love how we're not even talking about the baseball. We're talking about chili. But
it is still.
So what you're saying is that if the chili guy, this is a great example, by the way. I'll remember it. This is a good example.
It's because people think that, there's this baseball rule. So if I go to a baseball game and I get injured in any way, shape, or form, I just assume the risk. And it's like, no, if you go to back in the day,
the whitewater rafting was always a good one.
Or a Final Four basketball game. And Bobby Knight from Indiana decides to start beating a chair on the ground and then throws it into the crowd and you're hit with it and you're injured.
Right.
You didn't assume that risk. You assumed the risk of an error.
Well, maybe you should have. Well, no, I'm just kidding.
With Bobby Knight, it would be a fact-specific type thing. But you go to a basketball game, you assume that an errant basketball might come out.
Or somebody jumping to save a ball might come into the stands.
If you're in the first 3 to 5 rows, a player might come into the stands type thing. But if Bobby Knight chucks a metal folding chair 15 rows up because he's pissed off, which, he's pissed off a lot, and you're injured, you've got a recovery avenue because that wasn't something that you assumed the risk of. That's not something, just like the chili. You didn't assume that someone would spill hot chili down your back.
Right.
Yeah.
Or even assume that they would have it. And I always look at cases like this, even though, like I said, I'm the premise guy who does plaintiff work, I always look at it in reverse. And so when I was reading this, I'm always looking at, what is the defense going to do? Where are their defenses after losing the summary judgment motion? And it's a weird word to say loses. It's really not. All it is it just allows the case to be looked at. And so there's so many other defenses that Solaire and the Braves have. And it still comes down to what are you doing as an individual? If things are going crazy and everybody's celebrating and you happen to fall down the stairs, well, that's still on you, right? Even if they're steep, even if there's something wrong. So there's still so many ways that this could be kicked out. But to your point, Shawn, in real world practicality, this case is not going to be tried. It's not going to be kicked out. It's going to be settled. And the person who's injured probably is not going to get the full value for their damages. And then either Solaire, it's going to be a combination. Solaire and the Braves organization are going to come together and offer something that is below what the damages are, true damages are, but it's well above 0, which the normal baseball rule would kick it out. That's a real world application.
Okay. So the biggest takeaway from today is not all stadium injuries are automatically dismissed.
Yeah,
and watch out for the chili guy.
Well, yeah, and the waiver, like I beat this drum all the time, but just people don't realize it. But when you buy a ticket to any sporting event, you are agreeing to the waiver, and the waiver essentially says you cannot recover for damages that are in the ordinary course of business, meaning the ordinary baseball activity, the ordinary football activity. Yeah. But guess what? If you storm the field and climb up on the goalpost and it falls down and it collapses, you can't recover for that. Yeah. Like, that's still your decision to do these things. So it's still, even if you get past that first hurdle, which Shawn's talking about, it comes back on you of, are you acting in the prudent way? Are you acting in the normal way that a person would act in that situation? That kind of thing.
Well, and just to bring it home to, the Augusta, Georgia, where we're from, home of the Augusta National and the Masters Golf Tournament, the most prestigious golf tournament in all of professional golf.
Are you trying to get them to sponsor us?
Yeah, please.
If Scotty Scheffler, the number 1 golf player in all of the world, is on the number 10 tee at Augusta National and pounds a drive far left out of bounds.
Yeah, shanks it or something,
well, let's say he hits it right and hits a spectator.
Patron. Yeah, you're going to say it. You got to say it right now.
That patron assume the risk. They're watching golf. They know that happens. If he does the first thing that I said, nails one dead left, what I like to call, a power hook.
Power. You got the power draw. The power fade. The power fade. That's right.
And then gets, ticked off, turns around and throws his club into the patrons.
You've really thought about this.
And you're injured. Well, that's not something that you assume the risk of.
Right.
Yeah.
Same thing with Mr. Solaire. You didn't necessarily assume that after the game is over that you necessarily need to be paying attention to balls being thrown.
Well, is there not something to be said for having to, he didn't maliciously throw that ball to try and hit that lady in the eye?
That's
the difference between negligence and willful conduct. It's not an intentional tort. Yep. You don't drive down the road and intentionally most of the time run in the back of somebody.
Right.
It's because of your negligence. You're not paying attention, or you're doing something that is dangerous without you thinking, that it causes this type of injury.
Yeah.
It'd be different if they were having a dispute and she was saying, Mr. Solaire, you're
suck. Not the MVP of the World Series.
And he said, I'll show you. And he throws a 90-mile-an-hour fastball at her.
Yeah, yeah.
I mean, that rises to a different level.
That was something that was in the claim, though, I think, was that he threw it overhand.
Yeah, that's all garbage. That's just all. I mean, how are you going to throw it?
Where was he? Where was she sitting?
We still don't have any video of it. I searched high and low, and I don't have a video of him throwing.
That's going to depend on how, it's where was she sitting? How far did he throw it? Was it a line drive? Was it a little throwing it into the stands? All that stuff. That's all fact stuff. But the point I think, Shawn, that you made right there needs to be clarified is like it's intentional versus non-intentional. Negligence is not intentional. And if you have an intentional tort, like if Solaire intentionally did this in your hypothetical, well, the Braves have no liability because that person is acting out of what is normal. And so your car example, if you intentionally hit somebody with your car, well, you don't have insurance anymore because you did it intentionally, and your insurance does not cover your intentional actions. Right. So there's so many levels on this, and it's really the interesting thing to me is that it is just allowed. It is allowed to go further, and this is not something that is a normal thing. The baseball rule still applies to 99% of the cases. But if you're acting out of something that is not in the realm of normalcy in a sporting event, well, you may be able to recover. But it still has so many other levels after that.
But from a timeline place, though, because I want to be clear, like, yes, this happened in 2021. It's not unusual, however, for something like this to take this long, so to speak, right? Not. So I feel like we get that a lot just in day to day, right? Where people are like, why isn't my case going faster?
Yeah, well, you're injured in 2021. You have 2 years.
That's what people think it has to be over in 2 years. That's just when it has to be filed.
You have 2 years to file a lawsuit, and we don't know the backstory of whether or not they submitted a claim to them. Yeah. Informal, not in the legal system. Just, hey, our client was injured. We'd like you to pay X amount of dollars.
And one thing on that, Shawn, you have to, with your damages, you have to wait because she doesn't know what her damages are until the end of it. So let's say her damages took a year for her to heal or whatever it is. So that's when you're starting, is a year later. Yeah. But then, you have the ruling for the Superior Court that said you're kicked out. Well, then it has to be appealed. Then it has to come back. Like this thing could be
you got 30, 60, 90 days during this appellate process before it gets to the Court of Appeals. Then depending on when they get it and when they decide to hear it, could be another 6 months.
And if they say, like they did, they say, no, it's kicked back down. Well, essentially, when that ruling came back, you're starting at zero. You're starting at day one, and it might be 4 years, 5 years down the road, but it's day one as far as the lawsuit. I mean, that's just the way it goes. So, yeah, the 2 year is when it has to be filed, but by no means is that when it has to be over. And generally, if you have a case like that is very gray area of the law, if you're in the gray area of the law, it's going to take a lot longer. And with this tort reform crap and the House Bill 68 that passed, oh my gosh!
There's a lot of gray.
There's oh my gosh! And so, if you think the court systems were blocked up before, welcome to the new world. Every case is going to be 4 or 5 years. So,
well, and that's a whole other
But it's just it is, and especially
maybe next Friday.
maybe. Well, as always, we appreciate.
Love to talk about how my wife's insurance just went up 31%.
I thought it was supposed to go down, Shawn.
Tort reform.
I thought it was supposed to go down.
I thought it was supposed to go down, too. Yeah. She doesn't have any tickets, no accidents, no claims. 31% increase.
I don't know. Seems weird.
Yeah.
Well, as always, we appreciate our listeners and our viewers for watching the Layman's Law School. If you liked what you saw today and like to hear our banter and all these guys giving their expert advice, make sure you tune in, subscribe to our channel on YouTube, or also subscribe to our podcast, and we'll see you next time.